Mr. Sean Sherlock.
Chairman, the High Court has indicated that it intends to grant an order declaring sections 42, 43 and 45 of the Industrial Relations Act 46 and section 45 of the Act of 1990 to be unconstitutional. In this new bill, the response by Deputy OD has been to import the exact provisions of 4 original sections that had featured in the now lapsed Industrial Relations Amendment Bill 2009. That bill had been introduced, as Deputy Bruton has said, by the last government in the summer of 2009, but it had never proceeded beyond its second stage reading in this House, which was completed on the 11th of February 2010. Regrettably, that bill failed to make any progress in the last government's legislative programme before it eventually lapsed with the end of the last Dáil. The only real novel provision in this new bill is at section 7, which repeals section 45 of the 46 Act, which makes it an offence for an employer to pay to a worker remuneration less than the statutory minimum remuneration, or to fail to comply with statutory conditions of employment. This section, which the High Court ruled was unconstitutional, was the subject of recommendation 19 in the independent review, the Duffy-Walsh report. The Duffy-Walsh report recommended that the mechanism for ensuring EROs be brought into line with that for regulated employment agreements, and that, as an alternative to a criminal prosecution, a complaint could be brought before the Labour Court. The report recommended that NERA be authorised to bring such a complaint in respect of either an REA or an ERO. I welcome the proposal to decriminalise the initial steps in the enforcement process of EROs. It makes sense, as Kevin Duffy and Dr Walsh had recommended, to allow room for NERA to bring a complaint to the Labour Court on behalf of an individual or group of workers, rather than retain the current arrangements where enforcement is only by way of a prosecution before the District Court. Unfortunately, the incorporation of the proposed amendment on the enforcement of EROs at section 7 is the only provision in the bill that responds directly to the specific recommendations in the independent review report. This new bill does not contain any provisions to respond to other specific changes that were called for in the recommendations of the Duffy-Walsh report. The Duffy-Walsh report called, at recommendation 16 of the report, for all of the changes that were proposed in the Industrial Relations Amendment Bill 09 to be enacted, along with amendments to cover the additional recommendations made in the report regarding the legislative framework within which both the REA systems operate. It makes no sense to tackle this task in a piecemeal way, or to leave REAs to the mercy of some continuing legal challenges. Unfortunately, this bill does not address the significant range of changes called for by Kevin Duffy and Dr Frank Walsh in order to safeguard the statutory wage-setting machinery from the threat of constant litigation and judicial review. Not by a long shot, I would contend. Recommendation 1 of the independent review report also called for an amendment of the Industrial Relations Act 1990 to provide a means whereby the scope of the particular establishment orders of JLCs could be reviewed by the Labour Court. The report also recommended that the Labour Court be empowered to undertake periodic reviews of EROs in the interests of greater clarity as regards their purpose and the classification of the workers and the types of enterprises covered. Action with regard to these recommendations will be crucial to providing protection for EROs against further legal challenges. Is my time up?
1 minute.
Okay. Recommendation 9 of the independent review report also called for amendments to be made to the Industrial Relations Act 1990 regarding the constitution and proceedings of JLCs. This is another critical area in which action is now required in the light of the High Court ruling. Unfortunately, at a time when it is vital to provide more certainty for vulnerable workers in low-paid sectors, the proposed Industrial Relations Amendment Bill 2011, presented by the Deputy OD, offers only limited protection. And I'm convinced that the urgent preparation of substantive legislation represents the only reliable means of guaranteeing protection for vulnerable workers in low-paid sectors. Thank you.